Hello, future millionaires. Now, welcome back to another talking point where we discuss all matters relating to investment, business, and most importantly, property. Now, today we're once again lucky to be joined by our resident property expert who's going to delve a little deeper into the new laws and regulations of the Property Practitioners Act. Emile, thank you so much once again for joining us today.
Hello, Damien. Only a pleasure.
Now, for those who are new to our series and the channel, each week we release a talking point about a specific topic relating to investment. And Emile wrote a follow-up article to a very informative explanation of the Property Practitioners Act. Now, Emile, for those who may have missed our previous interview, could you please give us a little rundown of what the PPA is and why it was implemented?
Yes, Damien, the PPA, the Property Practitioners Act, replaces the old EAB Act, or the Estate Agency Affairs Act, which is very, very old. So they've basically updated the new act, made it more relevant, but also included a lot more professions, and not only real estate agents to be included into the law, and also be included as registered property practitioners. And the basic, or the most important reason behind it is to provide protection to the consumers out there. Although you know, a lot of people say that some of the professions included, you know, it's not really a good idea to have them in there, but it doesn't matter. It's about our consumers out there, and they're trying to look after them because property transactions are big transactions. It's expensive and really important.
Right. Now, Emile, in your article, you delved a little deeper into disclosures in particular. Now, according to the new act, what are the responsibilities of the buyer, the seller, and the agent?
Damien, yeah, the disclosure, people who's been in the property profession a long time probably is doing it already. We started doing it many, many years ago, but now it is law. Meaning, if you're an agent or an owner, you need to have that document completed. Property practitioners or agents are not allowed to take mandates, either to rent or to sell a property, if that document doesn't form part of the mandate, if that document isn't included in the lease agreement, and also not included in the sale agreement, then you have problems. You are breaking the law. So right now, it must be included. As an owner that uses an agent or a property practitioner, they must provide that document with every single thing that is wrong in the property. We will get to the different types of problems in a property, but the agent or the property practitioner needs to do a full inspection together with the owner of the property and stipulate everything. Once again, if the agent instructs the owner to fix something, then once again it must be removed off that report. But the agent can also be held liable if they don't provide the buyer or the tenant with that document as well. Attorneys are instructed to get that document. They will request it from you if you provide them with a sale agreement, for instance, and it's not there, they will ask you for it. It is law, and that's why they will enforce it. So owners doing their own rentals or sales, they must have that document there. Agents, definitely. If the agent does not supply that document and the transaction goes through, then the consumer can hold the agent liable, or the property practitioner, as they know now, can hold them liable for any damages as well. So the tenant and the purchaser can ask for it. And if they know that it is law, I'm sure they will.
Now, Emile, you mentioned this in your article, and you also briefly touched it now in terms of the different types of issues that could be found in a property. So could you just explain to us the difference between a latent and a patent defect?
Sorry, yes, I mean, obviously properties, they're not as straightforward as most other things. You know, when you can see a problem, i.e. a broken window, that's a patent defect. That's easy to find, easy to fix, if I can, you know, say it like that as well, because you can see it and it's easy noticeable. Latent defects, a lot harder. It's something that is usually not difficult, something that you are not aware of if you don't live in the property, meaning that if the owner is selling an investment property, he's not living there, and the tenants didn't tell him something that is wrong with the property, then he's also not aware of it, so he can't disclose it. Those are defects that comes out later on. Latent defects, and it's not easy to find them as well. Things like cracks in a wall, but the crack is behind the wardrobe in the bedroom perhaps, or a geyser that's not working properly. So if you buy a property and you move in, then you find out the geyser is not working. So those kind of things are called latent, and the seller or the owner of the property is sometimes not aware of it. But the big problem, this is where the consumer protection comes in with regards to the new act, is if the seller is aware of the problem and he hides it, then he is responsible. Doesn't matter when you find it out, even if the property is registered already, then you can hold the seller liable to fix that problem for you. And obviously, if you had damages, the same goes for damages as well. But it's not easy, and when you find it out after you've lived in the property for a few months, you will have to prove that the seller did know about it, and that's usually more difficult, you know, after the transaction has gone through and you live there for a year, 18 months. So it's, yeah, that's a difficult one. And yeah, the voetstoots clause then also come into play, where all sale agreements stipulate that you're buying the property voetstoots, meaning as it lies, as it is. In other words, if there is a problem and you decided to buy it, then you buy it as is. So that also plays a role.
So Emile, what happens in the instance where a new buyer purchases something from the seller? You know, you've signed the contract with a clause that said it's sold voetstoots, but a defect comes about at a later stage. How do you then prove it? What is the process that you would go through to try to prove that the seller knew about that issue before they actually sold the home?
Damon, that is difficult, you know, and it will also depend on the problem that you find. Let's take a roof leak, for instance. If you can see that there's proof that it has been fixed before, but the seller didn't tell you when you purchased the property that there is a leak, he perhaps painted the ceiling so you can't even see it from inside, then you can use the fact that he's fixed it before as proof that he was aware of it. And then you can prove it. I mean, obviously there's photos that shows repair, but things that are really difficult, let's say there's leaking pipes in the wall, and yeah, who knows where the leak is, who knows whether it is leaking, but later on you find that the damp comes through the wall, the paint is peeling, you know, that is more difficult. So did he repair the pipe and then plaster the wall again and paint it over it? Or did it only start leaking when you took occupation? So that is something more difficult. One good thing is if you're still in the transaction before registration, then you can actually put on hold on the transaction, sort that problem out, basically request from the seller to fix it. If he doesn't want to, let's say it's a lot of money, then you can still negotiate and make it part of the conditions to the sale agreement. Maybe negotiate a lower price to compensate you for it. But after registration, it will definitely make it a lot more difficult to prove that he knew about it and that the problem didn't occur after you become the owner.
Now, Emile, you've mentioned now that obviously if the transfer hasn't taken place yet, it gives you a little bit of leverage. But are there timelines in place for how long a buyer has to hold that seller accountable for latent defects? Is there a timeline in place stipulated with the Act, or is it pretty open-ended?
Not in the Property Practitioners Act, Damien, but in the common law, for latent defects, you can hold the seller responsible for those up to 3 years after you've taken ownership of the property. But once again, you must prove that he didn't know about it. And if you manage to do that, even 3 years after registration, you can definitely hold him accountable for the repairs of that property.
Fantastic. Now, Emile, just a scenario that's come up that I was thinking of while you were talking. What happens in the event where a seller is genuinely unaware of a defect at the time of selling? So an example is, let's say the seller did some renovations to their home, which included a lot of electrical work. The seller obviously obtained a certificate of completion from that electrician who did the work. And in their mind, everything was done correctly to spec and to standard. Now, once they sold the home and transfer has taken place, a fire breaks out in that home. And it's determined that the fire was as a result of poor wiring or wiring not being up to standard. In this sort of event, who then is held responsible? Is it the seller who may not have disclosed that there was renovation work? Is it the supplier who did the certificate of completion that they weren't doing it the correct way? Or is the agent in some way held responsible for this, for allowing the transaction to go through without doing all the checks and balances?
Damien, let me start with the agent. Because there is a law once again in place to get a certificate of compliance for electricity in this instance. That is a law outside of the real estate property practitioner or agent's domain. So once that is issued, the agent will accept that it is correct. The same with the seller. The seller is ultimately responsible to the purchaser, and he needs to hold the company or the person that did the electrical COC accountable for it, because they need to make sure that everything, doesn't matter renovation or old wiring or new build, it doesn't matter. They have their own law and regulations and conditions to which they need to adhere and to which they need to issue the certificate of compliance. So if they did not do that according to the standards that are put down, then ultimately the person who issued, or the company who issued the COC, will be responsible, but his responsibility will be to the seller and the seller to the purchaser. So there's no excuse there. There's already, that law has been in effect for a very, very long time.
Now, Emile, we've got a couple of questions that have come through from our viewers and our readers. So for those who may not know, every week we send out our Times newsletter, which contains expert opinions on everything relating to property, investment, tax, and business. And of course, we're focusing on property and the new Property Practitioners Act at the moment. So last week we had a couple of questions that came in, as well as this week. So Emile, I'm just going to run through a couple of them. One of them coming from Bianca saying, in terms of the Airbnb market, which is quite a hot market at the moment, when are you a property practitioner who has to register in terms of the new act when it comes to managing, i.e. you've got your own unit that you're managing versus managing for other people? Would you need to register then as a property practitioner, or only once you reach a certain number of units?
Damien, immediately when you start delivering a service for somebody else on property, either Airbnb or the normal real estate type of services, then you do need to register. Because you are dealing with consumers, that law will apply. If you Airbnb your own property, different story, it's your property, then you don't need to register. But as soon as you start dealing with other people's properties, you will need to register.
Fantastic. And then a question has come through from Michael, where Michael's now recently bought a home, and he says, my estate agent refuses to compensate me on my rusty roof. I've contacted her about the situation, but she blatantly ignores me, and it's going to cost me in excess of 70,000 Rand to replace all of the roofing sheets. I only discovered this when I climbed into the ceiling and saw the rusty sheets on the inside of the roof. So it seems the roof has been fixed over many years on the outside, but never on the inside. So in this situation with Michael, who then is at fault? Is it in fact the agent? Is it the seller who might not have done their full disclosures, or who holds responsibility there?
Yeah, Damien, it's quite vague, but if he calls it my property, I perceive that he is the owner. Whether it's sectional title or not, that makes a difference as well. Sectional title, the body corporate needs to look after the roof. If it is a freestanding house, then that is responsibility of the owner. What I don't understand is why you would say that the agent need to compensate him. You know, if the agent won't normally pay for repairs to an owner's property, unless they deal with the body corporate once again, and the body corporate need to fix it, he would then, if he has a claim it from the body corporate and their insurance, because there must be insurance under sectional title complex. But I can't see a situation where an agent should be responsible for the structure of a property, you know, to the owner. So 70,000 Rand or 1 Rand or 100 Rand, if you are the owner, that is your responsibility. It must be really a special agreement to get an agent to take responsibility for that. So I think we do need a lot more information in this situation to properly advise him. But in broad terms, you know, he needs to maybe take that into consideration to make a decision. But it would be very difficult for me to see how the agent could be responsible to pay him 70,000 Rand for a roof of a property that he owns.
Thanks for that, Emile. And then the last question we have came through from Bonita. So she says, we bought a house during the lockdown period 1 year ago. When we purchased the property, everything was in working order other than some minor issues with the plumbing, which was rectified by the seller. Now, after a year, our neighbor requested to speak to us, and the lady said that there was some water leaking into her yard for as long as she can remember. She confirmed that the seller was aware and told her that they are selling the house and she must not be worried, it will be fixed. So I asked the lady why she didn't come forward when she heard that the owner was selling, but she obviously didn't want to cause any trouble between the seller and she just kept to herself. Now, at the moment, it is the new buyer's problem. And she has contacted the seller, and after 1 year, he's basically said that it's not his problem anymore because they bought the property. So does the Property Act protect them after a year as buyers, or has this become a problem that they will now, as buyers, need to compensate instead of the seller, even though they didn't know about it?
Well, Damien, yes, there's a few important points that you mentioned. Obviously, the buyer did not know about it, and it was not disclosed by the seller as well. But now they've got proof from the neighbor that the seller was aware of it and it was not disclosed. So I perceive that the leak is somewhere where you can't see it, either underground or behind some buildings, outbuilding or something. So there is damage and there is repair costs. So in this instance, even after a year, they can take it up with the seller. It sounds like he's difficult and is not willing to pay for it, but in this case, they have a witness that can testify to the fact that the problem was there and that he was aware, because she made the seller aware. And yeah, if they take it legal, I'm quite sure that the law will see it that way as well. So they can enforce the cost to those repairs and damages to the neighbor, obviously, onto the seller. And so they don't need to pay for it as purchasers.
Fantastic. I'm sure Benita will be very happy to hear that news. So
Lockdown is not an excuse for that, Damien.
Exactly. Emile, thank you so much for sharing all of your insights with our viewers today. Obviously, no doubt we've all learned a little bit of something today. It's taking us one step closer to becoming successful property investors. Now, speaking of property investments, if you would like to find out more about how we help ordinary South Africans become successful property investors, then register for our free online training taking place this weekend from Saturday. And all of the details are in the description below. So have a look, click on the link, register, and make sure you watch. Emile, thank you again for all of your time. We really appreciate it. Your insights are always very valued.
Damien, it's a pleasure. Hope to speak to you soon again.
Great stuff. Thanks so much, Emile, and thank you to you guys for watching. That's all for now. So until next time, bye-bye.